Okay, so I understand that I'm supposed to introduce myself at the beginning of these for the benefit of the viewing audience at home, who apparently is not clued in by the tab that they click on when they go onto the UFC law site. But my name is Aziz. I've taught some of you in constitutional law or legislation, or federal counterterrorism, and in some instances, the federal habeas class that I'm teaching now. What I want to talk today about is a paper that is coming out probably later in the year, but is a work in progress. One where the manuscript of the article is something that I can still work on. So what I'm going to do is to spend about half an hour talking through the basic idea. And it's an idea that sounds in constitutional law. It has some commonalities with the material that gets covered in the basic constitutional law class, but it's not actually on any of the topics covered in that class. And then what I hope to do in the balance of time remaining, which I think will be about 15 or 20 minutes, is to open it up. And I'd be delighted to get your thoughts or reactions to the idea. So the aim of the project that I want to talk to you about is to defend and rehabilitate a rather lovelorn part of our federal constitution. And this is Article V. This is the section in the original 1789 Constitution that governs the textual amendment of the Constitution. To be brief, Article V makes textual amendment exceedingly difficult. And as a result of that, it's been heavily criticized. My contrary thesis is that our Constitution's rigid and inflexible rule for textual amendments has been vital to the document's survival, particularly in the first few decades of the Constitution's life. In that specific temporal period, in those first decades of the early Republic, Article V played, in my view, a vital role in catalyzing the development of key national institutions, including political and financial infrastructures that were essential to the nation's survival. But because Article V has been overtaken by other methods, extra-textual methods of constitutional amendment, we have forgotten, we have lost sight of the function that it played in the early Republic. And what I hope to do in the next 25 minutes or so is to redeem that lost functionality of Article V and to explain why we have, I think, what is fair to characterize as a two-speed constitution, a constitution that operates at least in two different tempos at different times of its existence. Now, to begin with, to praise Article V is to put oneself at odds with the conventional wisdom in the legal academy. Article V is the provision of our Constitution that scholars love to hate. They love to hate lots of parts of the law. But it's very hard to find anyone who sings the praises of Article V. It's said that Article V is a comatose provision of our Constitution because it renders constitutional amendments so difficult, nobody ever uses it. Correlatively, it's said that Article V renders our Constitution deeply countermajoritarian. It places the text within the icy clutch of the dead hand of the past. It makes us vulnerable, it makes us slaves in some fashion to the preferences of a group of white, male, propertied individuals who wrote the Constitution in the 1780s, right? And it precludes the correction of what today are perceived by some scholars as either unjust or undemocratic features of our present dispensation. So, for example, scholars like Robert Dahl at Yale, Sanford Levinson at Texas argue that aspects of the hardwired Constitution, such as the Senate's apportionment rule, the opaque scope of executive authority, and the open-ended terms of Supreme Court justices are all undesirable from a democratic vantage point, and yet cannot be amended given the obduracy of Article V. Now, motivated by these criticisms, scholars have identified a score of methods whereby ingenious Americans have amended our Constitution without moving through the process of textual change. So most obvious to law students of those extra-textual methods of amendment will be the process of change through judicial opinion, right? So those of you who've taken any of the public law classes will know that the Supreme Court plays a large role in altering the de facto rules on the ground that fall out from our Constitution's text. Another method of constitutional amendment, or functional constitutional amendment, is said to be the use of framework statutes. So this is not a new idea. The constitutional scholar Charles Beard at the turn of the 20th century pointed out that there were a score of statutes that had been passed by Congress when he was writing, things like the Sherman Act, that had what he called a constitutional status, right? This idea has been revived by two scholars called William Estridge and John Farragon, who wrote a book called A Republic of Statutes, where they say, look, most constitutional change in the United States is accomplished by what they call super statutes. Right? Again, they refer to the Sherman Act. They talk about things like the Civil Rights Act of 1964, things like the Organic Statute for the Federal Reserve, as statutes that have a functionally constitutional status. And then the third important method of constitutional change outside the text of the Constitution is through what the Yale scholar Bruce Ackerman calls constitutional moments. This is the idea that an enervated public acting in the open field of political competition can, through repeated success at national polls, change the national political dispensation in such a way as to effectuate large changes to the constitutional order. Right? His archetypal constitutional moment is the New Deal and the repeated electoral successes of FDR. Right? But those are all methods, it is argued, of altering our foundational governmental commitments without changing the text of the Constitution. Right? These scholars argue that we have de facto given up on Article V, de facto given up on the text of the Constitution as a dead letter, a nullity. As my colleague David Strauss says, our system would look the same today if Article V of the Constitution had never been adopted and the Constitution contained no provision for formal amendment. Now, the puzzle of Article V is, on this view, normative. Right? Why is it desirable to have this provision in the Constitution? But there is also a descriptive puzzle in our amendment rule. Right? And to see that, it's helpful to look at it through the lens of a comparative empirical study that Tom Ginsberg and two of his collaborators engaged in. Ginsberg finds that Article V is not just inflexible by American standards, but by global standards, it is one of the most inflexible rules adopted in the text of a constitution with respect to textual amendments. Unlike other constitutions, Article V creates a two-step process for textual amendment. At both stages of the process, there is a supermajority rule of some sort, a two-thirds rule in the first instance, at the proposal stage, and a three-quarters rule at the second ratification stage. The de facto threshold for constitutional amendments today is obtaining 2/3 majorities in both houses of the national legislature and then getting the agreement of 75 houses, state upper or lower houses, assuming, that is, you are able to get the agreement of Nebraska's single unicameral chamber. If you can't get Nebraska's, you need 78 houses among the states to agree with you. One early study, a study that predates Ginsburg's, finds that only the former Yugoslavia's constitution is more durable, is more rigid than our constitution. Now, this is not merely an aesthetic problem. According to Ginsburg, or according to his comprehensive empirical study, constitutional inflexibility is positively correlated with constitutional death. That is, rigidity promotes the demise of constitutions, right? They gloss this as follows. They say, look, a more malleable constitution is more open to a range of new interest groups who can find ways of incorporating their interests and values in the text of the Constitution. A flexible constitution is more able to respond to demographic, economic, technological, geopolitical change. And perhaps most importantly, it is most capable of dealing with the problem of mistakes in the original constitutional text, right? So Article V of our Constitution is not just an outlier in terms of how rigid and inflexible it is. It's also a positive puzzle. Our Constitution should have died a long time ago, if you think that Ginsburg's empirics have traction, which I think they do. Let me anticipate an objection here, or a sort of a potential explanation. The potential explanation is that it's precisely those extra-textual modalities of constitutional change that I alluded to earlier that explain the Constitution's survival. Right? It's the very fact that we don't use Article V that explains why the text of our Constitution has survived so long. Right? That turns out to be a partial explanation, but at least with respect to the period of time when the risk of constitutional mortality is greatest, not an explanation at all. Ginsburg et al. Find that constitutions are at greatest risk of dying within the first 2 to 3 decades of their existence. Within the first 2 to 3 decades of our Constitution's ratification, none of the methods of extra-textual amendment to which I alluded were available, right? The Supreme Court did not engage in serious constitutional interpretation until after the Civil War, Marbury and Dred Scott notwithstanding. Those are 2 exceptions. Congress did pass at least one, what now gets called a super statute before the Civil War. That's the 1789 Judiciary Act. But by and large, all of the examples of fundamentally transformative statutes come from after the Civil War. And again, the examples of constitutional amendments are all post-bellum. None of them are pre-bellum. So at least with respect to the question of why it is our Constitution survived that period of time when it was most likely to perish, extra-textual amendment mechanisms provide no answer. Right? There's a puzzle as to why the Constitution survives its first decades. What enables the Constitution to navigate those early parlous years? That's the question that I want to take up. Well, that's the question that I hope to answer in the paper. So here's my solution to this. My solution is that Article V is not epiphenomenal to the fact of constitutional survival. Rather, it's pivotal to the Constitution's survival because there are 2 mechanisms that connect constitutional rigidity, the rigidity of the text of the Constitution, with the fact of its duration, with the fact that it survives through time. Both of these mechanisms, I will argue, were in operation in the first few decades of our Constitution's life. So let me say what those mechanisms are, and then I'll unpack them a little bit. So first, rigidity mitigates a potentially fatal problem of hold-up that can arise in early on in a Constitution's life, that can preclude ratification up front, and that can lead to costly, frictional renegotiations downstream. Right? So there's a hold-up problem. The second point is that by mitigating the hold-up problem, constitutional rigidity encourages investment in sub-constitutional national institutions that are necessary to the Constitution's survival, and that function in this context as entangling devices, attaching or netting in core national interest groups into a particular constitutional dispensation. Right? So there's a solution to a hold-up problem, and there is a kind of locking in effect through sub-national institutions, of which I'm going to give you a couple of examples. Now, in thinking about these mechanisms, or we're trying to define these mechanisms, I'm drawing on a literature in law and economics. Right? There's a large literature on what's called incomplete contracting. This is the idea that you enter into some sort of temporally durable, long-term contract with, say, a supplier or a manufacturer. Think of the relationship between a coal mine and a steel processing plant, between a newspaper and a printing press, between an actor and a company that produces a television show that's ongoing, right? In each of these contexts of incomplete contracting, there can arise a hold-up problem, right? And that's going to be the first point of contact between the law and economics theory and the public law account of why constitutional rigidity is desirable. Most of you have encountered the hold-up problem in the form of the Alaska Packers case. Right, this is the case from first-year contracts that I assume almost all of you know, in which you have a ship, a fishing ship, going off the coast into the Pacific. The crew of the ship attempt to engage in a renegotiation of their remuneration contract while they are out in the Pacific, when there's no opportunity for the owners of the boat to replace that crew. When the owners accede to this renegotiation of salaries and contracts, when the ship returns, the renegotiated contract is subject to litigation in the Ninth Circuit Court of Appeals. The Ninth Circuit holds that it will not enforce the renegotiated contract. Right? The analogy is not precise, but the intuition is there. The intuition is that this is a case in which a court treats the original contract as rigid. It treats it as resilient to textual amendment, right? And from that intuition, you can develop a more general account of why textual rigidity is going to be valuable to incomplete contracting. And indeed, there's a Yale scholar called Christine Jols who has done that. Jols makes the argument that in many instances, parties to an incomplete contract are going to have an incentive to engage after the fact in opportunistic renegotiation of the contract, and we'd be more likely to enter into Pareto superior deals if we were able to somehow commit to contractual rigidity up front and not allow downstream negotiation. Right? Jols points out that in the private contracting context, this turns out to be very difficult to do for practical reasons. Right? It's very difficult to stop parties entering into some kind of offsetting private side contract that some court, either in the same jurisdiction or in some other jurisdiction, is going to enforce. Right? So in the private contracting context, textual rigidity solves a problem in incomplete contracting, but it's very hard to use. It's very hard to use because of the side contract problem. Translate that basic intuition over into the public law context, and we start to gain some traction on why Article V is in the Constitution. Right? The first thing to note is that the problem of side contracting that Joels identifies is not so much of a problem in the public law context. It's not quite clear what it means to enter into a side contract after you've entered into a constitution and to find some third-party enforcer that will enforce that side contract. Right? The analogy is not quite there, and so one thing that we might start off, or one premise that we might start off with, is that the solution of textual rigidity is a solution that might work better in the public than the private context. How might that be? How might that be so? So consider this as a sort of generalized account, right, of how you might use textual rigidity to ensure constitutional survival. There are a whole slate of interest groups, nationally powerful interest groups. Call them states, call them plantation owners and northern industrialists. Doesn't really matter how you conceptualize that. But there's this bunch of interest groups that are coming to the table to negotiate a constitution. And they need to negotiate it in the form of a text, and they want that text to be temporally durable, right? What they're going to negotiate is going to be necessarily incomplete. Right? They're not going to be able to anticipate and to write down solutions to all conceivable problems that might arise in the future. And then once ratified, once the contract has been entered into, these interest groups are only going to get payoffs from this new constitution if they all engage in investments, if they all engage in some kind of shelling out in order to make the new dispensation work, right? So it's not enough in our constitutional context just to have this document, right? You need to do things like start allowing for the collection of taxes in federal territory. If you're an interest group, you might need to invest in political organization that takes the form of early party structures, right? You might need to adapt your fiscal and monetary framework in order to allow the federal government to take up some other roles, right? You need to do things that are costly in order to make these national institutions work. But the thing is that these investments that you make are going to be tailored to the new constitutional dispensation, right? So if there's a particular kind of party system that's going to work in our new constitutional order, right, let's say it's a PR system with party lists, you're going to have to invest in the costs of creating the right kind of parties, the right kind of political infrastructure, right? The same point can be made with respect to trade relationships. And those investments that you make put you at risk of hold-up. They create the risk that some other interest group is going to turn around after you've made your investments and say, hang about, no, I can think of a better deal, and let's renegotiate this constitution, this contract. Let's come up with some other way of distributing the welfare gains that it produces. And you might have to do it because you're on the hook by dint of your previous investments. Right? This is basically the same problem as the problem that private parties face in the incomplete contracting context, where they have to engage in investments in order to make their incomplete contracting work. It's the same problem that the fisherman and the boat owner face in Alaska Packers. It's the problem that the printing press and the newspaper might face, right? The printing press might have to buy a certain set of bespoke equipment in order to print this newspaper, right? It's the problem that actors and television shows face. The most famous example in that context is James Gandolfini, who after the first season of The Sopranos basically held up HBO by demanding triple his original salary, right? Asset-specific investments leave you vulnerable to hold-up, right? Same problem in the constitutional context. If you're a rational interest group thinking about whether to enter into this constitution, you're going to be worried about that hold-up problem downstream. You're going to think, well, I don't want to put myself in a position where I'm vulnerable to that. And just like the participants in a private contract, just like the boat owners in the Alaska Packers case, you might prefer a situation or a contract that is inflexible. You might prefer a contract where there are fewer rather than more opportunities for strategic hold-up, right? Where strategic hold-up might involve adding to the text of a constitution, or it might involve taking it away. There's no, I think, directionality in that way. And this concern about strategic hold-up, right, might lead you to say, look, unless there's a rigid amendment rule in the constitutional deal that I'm going to enter into, it's too risky for me, right? I'm not going to do it, right? So this is a way in which the Constitution's rigidity can solve a problem of strategic behavior by national level interest groups that might preclude, on the one hand, the Constitution from being ratified in the first instance. And then let's say you do have a Constitution that's ratified. If you have too easy an amendment rule, what you're likely to see is that strategic behavior in fact working out on the ground. You're likely to see efforts at redistributing the gains from constitution making in ways that are costly, friction producing, and ultimately inefficient, right? So from either the ex ante or the ex post perspective, constitutional rigidity might be desirable, right? A useful way to think of this, and a way that connects this to the writings of an important political scientist called Albert Hirschman, is that what's at stake here are three different options. Option one is adhere to the contract, option two is modify the contract, and option three is exit. And so the mechanism that I've described is taking the middle option functionally off the table, right? And by taking the modify the Constitution option off the table, you're making it more likely that people are going to enter into and then adhere to the contract. So that's the first mechanism. But there's a second mechanism, I said, and it plays out as follows. Textual rigidity, because it reduces the likelihood of strategic efforts at renegotiation of a contract, provides a positive incentive for parties to invest in those institutions that make the Constitution worthwhile, right? National political institutions, national trade-related and fiscal institutions. Those cooperative investments, right, once they're in place, then reduce the risk of exit, right? So you have adherence, modification, or exit. The first step of the argument is to say, well, look, here's how we take modification off the table, but the very mechanism that takes modification off the table also makes less likely exit. So that's the second mechanism. Let me unpack that a little bit further. Right, so again, we have these original interest groups, be they states or national level factions, and they have to decide what kinds of infrastructure are they going to invest in, which roads, which ports. Are you going to allow the development of a large agricultural industry in a large agricultural formation in your state, certain kinds of plantations, on the expectation that within the same country there are going to be factories that will benefit from this agricultural investment? Will you assume that there is such trade in the future? What kind of political parties are you going to engage in? If you're a state at the time of at the beginning of our constitutional history, are you going to allow for the national bank, which Alexander Hamilton creates, to take over much of the job of regulating credit and providing and regulating the money supply? Are you going to allow your banks to form in ways that are sympathetic, are conducive to that allocation of national authority. There's all sorts of decisions, decisions that you have to make that are related to asset-specific investments in ways that tailor your particular industrial, trade-related, political organization in light of the way that the national government is developing. Right? You have to decide, that is, how asset-specific your investments in national development are going to be. Now, the more confident that you are that your investments are not going to be taken advantage of by strategic negotiation, the more likely you are to make asset-specific investments. The more asset-specific investments that you make, the more entangled you become in this specific constitution. The more, in other words, skin you have in this game. So just as the textual rigidity mechanism is producing institutions in ways that solve the problem of strategic renegotiation, it's also raising the cost of exit, right? Just as an aside, this connection between the creation of subnational institutions as a prerequisite to constitutional survival and the diminishing prospect of exit explains another textual peculiarity of our Constitution. It's very odd that our Constitution says nothing in its text about secession, right? The legality of secession by a state is de facto resolved by the Civil War. But one way of thinking about the secession problem is that the framers didn't need to put in a rule about secession because they already had embedded in Article V a mechanism that made secession unlikely. Not impossible, right, as we see, but unlikely. So to summarize, the much maligned Article V performed two important tasks in the period of our early republic. The first task that it performed is that it solved a strategic hold-up problem that would have prevented investments in necessary national institutions. The second problem it solved was that it reduced the likelihood of exit by important national interest groups by entangling them in those very same national institutions. Parties and banks are the ones that I develop at some length in the paper. So, if there is a problem with Article V, it is not that it yields too rigid a constitutional text. The problem with Article V is rather that it yields too rigid a constitutional text for too long. On the one hand, what works in the early republic to address the hold-up problem, to elicit entangling national institutions that preclude exit, over time becomes increasingly dysfunctional in a world of fluid and ever-changing economic, geopolitical, and technological conditions, in a world in which we realize with increasing sharpness the moral errors of our founding fathers, particularly as they pertain to slavery. But on the other hand, rigidity-induced investment in new national institutions, such as national courts, the federal court system, such as national bureaucracies and a robust national public sphere in which Congress can operate in, such as national political movements that mobilize for fundamental change, be it with respect to abolition or be it with respect to the solutions to the Great Depression. All these are products of textual rigidity in some way. So Article 5 might sow the seeds of our Constitution's death, as Professor Ginsburg argues. But at the same time, it breathes life into instrumentalities of its own persisting vitality. That's the paradox of Article 5. It is the begetter as well as the destroyer of constitutional survival. Accordingly, to recognize Article 5's more nuanced and important role in the early republic is to reconsider the relationship between the various modalities we have developed for amending our Constitution. That our Constitution survives to the present day is a testament to its early textual rigidity, but it is also a testament to the institutional fruit of that rigidity. It's a testament to the ways in which politicians, members of the public, and yes, judges, have found ways to innovate to deal with the limits of the original constitutional dispensation, right? This is why I began by saying we have, in effect, a two-speed constitution. We have Article V-induced rigidity at the beginning of our republic, and then as time goes on, particularly after the Civil War, we have a suite of extra-textual amendment mechanisms, the fruit of those original subnational institutions, right, that over time have fostered sufficient flexibility for us to deal with at least some, perhaps not all, of the moral and social welfare failings of the original constitutions. And if that's right, the method of textual amendment in Article 5 is not a competitor to change through the Supreme Court, to change through super statutes, or change through constitutional moments. Rather, textual and extra-textual modalities of constitutional change are complements. They are not substitutes. They operate at different times, in different ways, to solve different problems. And if that's right, what many have construed as infidelity to our Constitution, right, the recourse to courts or statutes to change fundamental commitments, is nothing of the kind. It has, in fact, been our Constitution's saving grace. So what I hope this the argument does, right, even if it doesn't convince you about the particulars of the textual mechanism that I have identified or I've claimed, I hope it is an opportunity to reconsider the subtle and ever-changing relationship between the diverse modalities of fundamental political change that our resourceful, ingenious, fortunate, and very peculiarly long-lived nation has evolved. And with that, I'm happy to take your questions. Jordan.
So do you have a theory as to why there's such a consistent trend of, except for the United States, in terms of rigidity being linked to constitutional death? Is it a lack of transition in time?
Yeah. So if you look, there's a section of the paper which I ought to put on SSRN, and I will in the next couple of weeks. There's a section of the paper that takes Ginsburg's comparative constitutional database and looks at the fate of rigid constitutions, and it finds that the United States is by an order of magnitude an outlier here. And the question is, why is that? Why is it that other constitutions can't benefit from the same mechanism? And I think that there's a couple of reasons. The first reason that I would give is that this is a strategy of constitutional design that is only appropriate in a limited class of cases. This is a strategy of constitutional design that's appropriate, A, when you have a background condition of oligopolistic political competition at the time of the Constitution's founding, right? This only matters, in other words, if you have a plurality of powerful interest groups that might engage in hold up against each other, right? In circumstances where you have no plurality of groups, where you have basically a monopoly on political power, right? It's not a problem, right? The most important condition in the international and comparative context where you have that monopoly is colonial or enforced constitution making. So think of the Japanese constitution after World War II, right? It's sort of the paradigmatic example. There are many instances, that is, in which either you have a monopoly holder of power, a dictator, a king imposing a constitution, or you have some outside authority that serves as the guarantor of constitutional stability. In those cases, you don't have a hold-up problem, right? So that explains why this isn't why rigidity is not valuable for many other constitutions. The other reason it's not going to be valuable for many other for other constitutions is that in many instances, a nation or a political community will already have a suite of institutions that enable that nation to function effectively. So here, think of the post-Soviet nations, which after the fall of the Berlin Wall, transitioned from being communist Soviet satellite states to being independent, self-governing institutions, right? There are many things those nations lacked, right? But they had police forces, they had political elite, they had, in many instances, something like a party structure, right? Think about Poland and the role that the trade unions played in Poland as sort of nascent opposition parties. There's no need for institutional investment, right? And that's going to be true in many times. France is another good example, right? France has had 5 constitutions over a period of time in which they've had robust institutions operate, probably too robust, right? Operating throughout in the background, right? So what do those two conditions tell us? They tell us that in many, many instances, all of the series of gains that I have identified as being correlated or caused by rigidity in a constitutional text just don't arise, right? And so in many instances, what we're seeing in the data is a rigid constitution being adopted by a Somoza or another sort of monopolistic actor that's just seeking to entrench themselves and their heirs, right? And in some instances that succeeds for a couple of generations, but by and large, it turns out it fails, right? So the gains to be had from constitutional textual rigidity are, I think, uniquely exploited in the early American context. And it's actually hard to think of other instances in which a nascent constitution is going to gain from those, gain in the same way. Is that responsive? James?
So my question is about why the powers that were in the early republic considered Article V to be a big obstacle to a wholesale renegotiation of the Constitution.
Yeah.
After all, they just did a wholesale renegotiation of the Constitution by framing the Constitution.
Yeah. So to give your question force, it's worth stepping back and pointing out that as a background matter, our Constitution is illegal. The regime that preceded the Articles of Constitution, the regime that preceded our Constitution is called the Articles of Confederation, right? This is the originary Constitution that the colonies post-Treaty of Paris enter into, right? This is what follows independence, right? The Articles of Confederation say, yes, you can change the basic constitutional arrangements, but you need to do so unanimously, right? The initial ratification rule for the 1787 Constitution is not unanimity. And you don't get unanimity originally. North Carolina and Rhode Island don't agree to they don't ratify originally. It takes them a few years. I think it's the early 1790s that both of them ratify. And so if you take as a benchmark the legal regime under which the framers were operating, which is the Articles of Confederation regime, then our Constitution is an extra-textual, nay, even an illegal amendment to that regime, right? And James's question is pushing, why, if you can do that once, why not do it again, right? And to sharpen that point, one can look to the writings of people like Jefferson. Jefferson, and he's not at the Philadelphia Convention. He's in Paris as the representative of the United States at that time. Jefferson says, look, no constitution ought to live more than 20 years. Right? Every 20 years, we ought to go back to the beginning, and we ought to, sever the icy dead hand grip of the past and rethink things from scratch. This is Jefferson, the radical Democrat. So why don't people listen to Jefferson? Why don't people step outside the constitutional framework as they did with respect to the Articles of Confederation? I don't think that there's a legal answer to that question. I think it's an answer that's fundamentally sociological and historical and political economic in nature. And I think it has a number of different strands. One strand is theoretical or ideological. It's the strand that people disagreed with Jefferson. So Madison in the Federalist Papers says, look, yeah, it's all well and good to have a constitution that's obtained democratically and that's renewed every once in a while, but that's no way to run a nation functionally, right? In order to have a nation that succeeds, that prevails in a dangerous geopolitical world, you need to have an abiding constitutional order that has a degree of stability. So one thing is that people just don't buy the argument that we need to renew every generation our constitutional commitments, right? The other strand of argument is very gross and crude. It's the idea that there's an opt-out, an illegal opt-out from the Articles of Confederation because the Articles of Confederation are not working, right? They're not working because states are not paying the sufficient payments on the debt that has been accrued through the Revolutionary War, and by the failure to pay those debts, the United States, the various colonies are increasingly at risk of entering into another war with European powers, of finding different pieces of the 13 colonies picked off by the Spanish, the French, and the British, right? So there is a very, very practical reason why you need to change the Articles of Confederation, right? It turns out that entering into the 1787 Constitution yields us a dispensation that, by and large, works with respect to geopolitical threats, right? It solves the problem of the national debt, right? It solves that problem through an innovation that, at least arguably, is unconstitutional, even under the terms of the 1787 Constitution. That's the national bank that Hamilton sets up that ends up playing an important role in regulating the payments of debts to the national government by the states, that de facto controls the supply of credit, which is credit in this instance is the creation of new currency, which is done by the state banks, right? It solves the fiscal problem that the Articles of Confederation was being sunk by. It also solves the military problem, right? It turns out that the US, even within those first few decades, is able to muster effectual military force in those instances where it's needed, right? The early rebellions, like the Whiskey Rebellion, are met with effectual military force. So I think the answer to your question is that we don't see a successful move to illegal constitutional opt-outs from the 1787 Constitution because, by and large, people are happy with it in a way that they're not happy with the Articles of Confederation, right? The caveat to that is that we do actually see in the mid-18 teens, a movement to opt out. Right? It starts out with something called the Hartford Convention, which is a convention of northeastern states, which seriously talks about redoing the constitutional order. This is in the that's in the context of the War of 1812, which is deeply unpopular. And then we start to see serious pressure from southern states over trade-related disputes with John Calhoun, the dispute about the Tariff of Abominations. That in turn leads to, or over time will lead to the Civil War. And then we do have what some people view as a form of constitutional failure. Am I responding?
Well, I mean, so I guess my main concern was with so it seemed like your thesis is that the rigidity of Article V gave interest groups confidence that the constitutional order wouldn't be renegotiated, which allowed them to make asset-specific investments.
Yeah.
Why would it give them that confidence, given that they just saw a very rigid constitution be renegotiated?
Well, it wasn't renegotiated. It was you didn't modify it. You just exited it, right? So I think the sort of the within the paper argument there is that the risk you're identifying is the risk of exit. And what mitigates the risk of exit is asset-specific investments in national institutions like the political party structure that develops in the early Congress, like the financial infrastructure, the relationship between the Bank of the United States and the several states, like asset-specific trade investments with respect to particularly cotton and sugar, right? It's all of that network of specific investments that mitigates the risk of exit, but to give the question, I think, its proper credit, doesn't take it away, right? At the end of the day, right, in the 1670s, there is exit, right? South Carolina and the other southern states exit, right? So I'm not making the claim that this was a perfect solution. I'm going to look over there just because, the sovereignty of this row. Mishan?
Are there situations then when you think the amendment system still is the necessary mode of changing the Constitution as opposed to the methods that you outlined, like judicial interpretation and statutory, amendments? Yeah.
So the question is, are there amendments when a textual amendment is necessary? Observationally, I think the answer is yes, with respect to particularly those features of governance arrangements that are very hard to change through the other extra-textual methods that I identified. So I think the first and the best example of what ends up having to be a textual amendment is the 12th Amendment. Right? The 12th Amendment arises because in 1800, the presidential election ends in a dead heat between Thomas Jefferson and his running mate, Aaron Burr. Aaron Burr tries to bribe opposing politicians into supporting him. You have an agonizing series of votes in the House of Representatives, which is the body to which determinations of presidential elections is committed under the original draft of the Constitution. The House of Representatives, by the way, is dominated by the Federalist opponents of Jefferson and Burr, which makes it a peculiarly terrible institution to solve the election. It's rather like giving, the resolution of a contemporary presidential election to, a Supreme Court that's dominated by, oh, never mind. So just ignore that last comment. So the 12th Amendment's a solution to that, right? This 12th Amendment is an effort to fix it by decoupling the presidential and the vice presidential ticketing arrangements. And it's very hard to see how you can do that through anything except for a textual amendment. So I absolutely think that there are some instances in which only a textual amendment works. The contemporary version of that might be, it's not in the US context, but in other contexts, is emergency powers provisions, right? So we know from the Weimar Constitution that precedes the Nazi regime that emergency powers provisions are extraordinarily dangerous. And it may be that the only way to deal with an emergency powers provision is through textual amendment, right? There are many people who are serious comparative constitutionalists who argue that that's the case for emergency powers provisions. Is that responsive? There was a question over here. Sir, I don't know your name.
Kevin.
Kevin.
I just want to know if you could talk a little bit more about why you think the extra-textual methods of amendment weren't at play before the Civil War. I mean, it seems like a lot of like dealing with the bank, dealing with like the federalist, anti-federalist, like electoral shift. A lot of that was extra-textual constitutional interpretation. If that's your first impression.
Yeah. No, I think that's fair enough. Yeah, right. And so, you know, again, to give force to the question, if you go back and look at David Curry used to teach here. David Curry's books on the Constitution in the Supreme Court and the Constitution in Congress, particularly the latter. Curry describes a great deal of constitutional discourse in Congress to a degree that is, to our ears, shocking. Right? We compare what the Congress then was doing with what our Congress now today does, and there's a large gap. It's not merely nostalgia. So I don't want to say that there's no extra-textual constitutional amendments going on in the early republic. I think there clearly is some, right? And I think that the best, where we see it most is in Congress. We don't see very much Supreme Court. We don't see the Supreme Court being used as a channel for extra-textual amendments. By and large, the Supreme Court is trying to get out of the way, right? That's the basic thrust of a very important case called McCulloch. The Supreme Court gets out of the way of other political forces that are pushing institutional change, right? But within Congress, I think that the forms of extra-textual constitutional change are there, right? It's the creation of the federal judiciary in the 1789 Judiciary Act that I mentioned. And it's, again, to go back to the example of the bank, I think the first bank and the fiscal infrastructure is extremely important, right? What I would say is that there's a little bit of that, but there's just not very much. And it's only with the Civil War that we really start to see an acceleration as national institutions gain tremendously in confidence, right? The Civil War marks this dramatic shift in federal jurisdiction, right? We suddenly start to, Congress passes a raft of measures that amplify the power of the federal courts, right? We have federal question jurisdiction, we have the first real bankruptcy courts, we have the US Court of Claims, we have removal jurisdiction, we have an enormous expansion in habeas jurisdiction, right? So the federal courts start to become a real institution, right? If you look at the sort of the graph of how many laws the Supreme Court invalidates on constitutional ground, it's basically flat until the Civil War, and then in the 1870s shoots up, right? So the behavior of the court changes dramatically. I would submit that the behavior of Congress changes dramatically too, right? That we see a couple of major pieces of legislation in the very beginning of the Republic, right? And then we see some important pieces of legislation in the 1820s and 1830s, improvement bills. But it's really in the post-bellum period that we start to see Congress through the ICC and other regulations of interstate commerce really start to dramatically change the fabric of federal state governance, right? And that reaches its apogee with the New Deal. And so I think you're absolutely right to say that there's some extra-textual amendment going on prior to the Civil War. But I think that there is a discernible shift in confidence and the velocity of change with the Civil War. And I would submit that's a testament to the success of original institution making that I've argued can be linked back to the original Constitution's rigidity. Is that responsive, Cameron?
Yeah.
Okay, thank you.